Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I've got a bit of a rant, and that's about an idea that's crept into the legal system which tends to undermine the presumption of innocence and the right to a fair trial. What I'm talking about here is the notion of self-serving evidence. So what is that? Well, self-serving evidence is evidence that would tend to get you something that you want. It tends to benefit you in some way. And so the suggestion is that you might have a reason to make stuff up if it's going to benefit you. So you might be thinking, what's the problem? That makes sense, right? Problem is, when we apply this to the actual accused person in a criminal trial, it becomes very unfair. And to get there and to sort of show why, we need to do a little bit of logical reasoning on this one. So let's say I accuse you of stealing my car. I say, you stole my car, you've been brought in now, you're facing trial. And clearly your goals are to be acquitted of this crime. Either you did steal the car, in which case you'd like to get away with it, or you didn't steal the car, in which case it would be unfair if you were convicted and sent to jail for this. Either case, either the guilty or the innocent wants to be acquitted at trial. And if you wanted to be convicted, you wouldn't go to trial in the first place. You'd just plead guilty. There's an easier way to get there. So anyone who is accused of a crime and who gets to trial is somebody who wants to not be convicted of that. So that's their incentives. Now, when we look at the kind of evidence they might give at trial, we can really break that down into three categories. The first category is irrelevant information. It's just, I work at Kmart or whatever else, something like that. Sure, it might come out at trial, but nobody cares. Okay, but that's not really a big deal. You might also say something that actively hurts you. Sure, I stole the car, but all right, well, yeah, you might confess midway through the trial. It almost never happens, but if you wanted to be convicted in that fashion, you'd probably have just pled guilty. But sure, you might say something harmful. Anything else, anything that tends to benefit you and make it less likely that you're convicted, even just straight up saying, I didn't steal the car, is going to be self-serving in some fashion because we've already established that your incentives are to not be convicted. And so really, when you apply this to the accused person, it basically translates to, sure, he'd say that because he doesn't want to go to jail on this. Now, did you spot the assumption that just crept in, which is really that's an assumption of guilt? Saying that we are going to give less weight to the accused person's testimony in their own defense because they're the accused person testifying in their own defense is really pushing hard on the scales of justice towards conviction. And this is something we don't typically apply to other people, even when it might make sense. This police officer who's testifying will say, oh, well, this isn't self-serving on the part of the police officer, even though that police officer might really want to see a conviction and might in fact have financial incentives, however distant, because they might be, for instance, chasing a promotion. And they're more likely to get promoted if they're getting convictions than if they're, say, found to be violating people's rights. So, but there we don't typically say that the officer's evidence is self-serving. And frankly, it's not the same degree of unfairness when we're talking about, an officer or a witness, but we still apply it less often. So this, I think, is a big problem, and there's lots and lots of cases where you see people's evidence rejected as self-serving. But thankfully, there is a bit of pushback that's starting to happen in the courts. And so I want to look at one of those cases because I sort of agree with it and I sort of don't. And I want to sort of show you how this case handled it and explain what I would have done differently in their shoes. So this is the case of the Queen and Taitong. I hope I'm pronouncing that right. And I'm not going to cover the full case. This is an allegation of sort of fondling, but we don't need to go over the facts for this one. We'll just summarize or we'll just go through the critical bits. So they've had the trial. We're skipping over all of the facts here, but they note The trial judge accepted the appellant's account of everything, and the appellant is the accused in this case, except his denials of touching and kissing the complainant. So everything was accepted except when he said, I didn't do the crime, because that's what he's being charged with. And the rejection of this went as follows. I reject Mr. Taitong's evidence about what happened between him and TB in the office while the boyfriend was away. His denials are self-serving, and I do not believe him. So that's it. That's what was said as a reason not to accept it. On the other hand, the trial judge noted the inconsistencies in the complainant's testimony, but found her account of the appellant touching her to be credible. The appellant submits that the trial judge erred by rejecting his denial solely because it was self-serving. He notes the trial judge actually preferred his testimony over that of the complainant on a number of points, and that the trial judge was unable to identify any falsehoods or internal or external inconsistencies in his evidence. So this is talking about how we assess credibility, because a lot of these cases come down to credibility. If something happens between two people and no one's around to watch it, and it's not something that would leave physical evidence like injuries or, stolen property or damage or anything like that, it'll often come down to two different people giving a different version of events. And so when we're assessing credibility and we're trying to determine, in a court, whether someone's being honest, you look at things like their demeanor is one aspect, but especially things like whether their statements are inconsistent with other things that you know to be true. If somebody says, oh, I never touched his car, right? I stayed well away from his car. I never touched it. But we find that person's fingerprints and DNA inside the car, then that suggests that they're not being honest with us, right? Because there's an inconsistency with the evidence. That would be an external inconsistency. An internal inconsistency would be if I tell two different stories or two different parts of my story don't match up. So further, the trial judge did not find him to be evasive or argumentative in terms of style of answering questions, nor did the trial judge identify any concerns with his behavior while testifying. The appellant submits that in such circumstances, dismissing his evidence denying the offense as self-serving was unfair. All right. And you see that the trial judge actually believed the accused person on some points, even over the complainant. So the court says, we agree. The part of the appellant's evidence that the trial judge dismissed as self-serving was a simple denial that he had engaged in the offense alleged. That denial was unembroidered by any peripheral evidence that might be thought to be self-serving. To be clear, this case was a pure credibility case. There was no corroborative evidence of any kind. So again, just a pure one person says one thing, the other person says the other. And if the denial, saying simply, I didn't do it, is self-serving, well, then the only reason it's self-serving is simply because you're accused of the crime. And that gets us to, because you're accused of the crime, you are less worthy of belief. That's an unfair trial. That's putting our fingers on the scale. Characterizing an accused evidence as self-serving does not necessarily disclose an error of law, where, for example, the use of the descriptor is contextualized with an articulation of why the accused evidence is self-serving or why, overall, the accused is found to be not credible, and they cite to a previous case here. However, a simple denial is consistent with the presumption of innocence, and to reject it as self-serving, without more, would undermine that presumption and the concerns underpinning the seminal decision of the Queen and W.D. And that's a case that is a critical case on how we assess credibility in these kinds of cases. One may rhetorically ask, what more could an innocent person say in such circumstances? As noted by this court in Queen and C.K., a mere denial cannot be turned into a reason to disbelieve the accused. To do so would also place an unwarranted burden of proof on the appellant. So you're presumed innocent. You don't have to prove yourself to be innocent. It's actually the government that has to prove the opposite of that. It was an error for the trial judge to reject the appellant's evidence denying the allegation simply because it was thought to be self-serving. And they also say, as to the third incident complained of by TB, the trial judge said, I do not believe Mr. Taitong's evidence about this incident. His reporting is contrived. The evidence is self-serving. Our concern is that the trial judge, having earlier wrongly thought that a mere denial could be rejected as self-serving evidence, may again have placed significant reliance on that misunderstanding in rejecting the appellant's evidence in response to this allegation. That concern leaves this conviction unsafe. So in this case, they reject it, and that the conviction is overturned because they say this is not a fair basis. Now, I agree that with the conclusion here that the conviction was unsafe, that it should have been overturned, but I probably would go a little further than they did, because the paragraph or the portion that I don't like, that I disagree with, is this portion right here. Characterizing an accused evidence as self-serving does not necessarily disclose an error of law where, for example, use of the descriptors contextualize with an articulation of why the accused evidence is self-serving or why overall the accused is found to be not credible. To my mind, the use of the phrase self-serving and the use of that rationale is always going to be problematic, even if you've got a description of why, because we know that the accused motivation is always going to be to not be convicted. And so this always is going to push the scale in favor of conviction. It's an unfair principle, and it's one that essentially says that you're less believable simply because you've been accused of a crime. This is something that helps convict both the guilty and the innocent. And it's that second part that should really concern us here. Because what else is an innocent person supposed to do than get up and say, it didn't happen? And you may not actually be able to provide anything else, right? It might be that you're sitting at home, you are reading a book, you are home alone, there's nobody to back you up, and the neighbor says that he saw you steal his car. And all you can do is say, it didn't happen. I was at home. I was reading. I was just not doing these things. And I don't know why the neighbor said this. I don't know why, why this is happening to me, but I didn't do it. Rejecting that as self-serving essentially presumes from the start that you're guilty unless you can show otherwise. And that to me is a big problem. When they talk about saying that you can articulate why overall the accused is found to be not credible, it seems to me that you can do that without saying it's self-serving. And that once you get into that notion of the accused evidence is self-serving, that this really suggests the very strong possibility that not only are you looking at, a situation where the person is being rejected because there's actual credibility problems, but also that in the judge's mind, they've done that pushing on the scale, that that we've already got that concern. So I would love to see the courts take a stronger stance on this. And there are some other decisions recently that have criticized this phrase, but it hasn't really reached the point that I think it needs to just say, if this is how you're thinking about the case, you're thinking about it wrong, and you're approaching the case in a fashion that is fundamentally biased against the accused person. That's really where I think this needs to go. But we're not there yet. That isn't the law at this point. The law right now, he could have been convicted if they'd put more reasons into it. And as far as we know, he might actually, it may not have happened. That's the critical thing. He was ultimately acquitted by the appeals court, but, we always need to ask the question, what if it didn't happen, right? That's really why we have a trial system, is because, and a lot of people are really upset about bail right now and saying, why do people get bail? Well, what if those people didn't do it? Is always, it's why we have a court system. It's why we have trials, because there are innocent people who are brought into the courts and forced to face the full might of the government to try to send them to jail. And they deserve a fair fighting chance. That's all that we really want, is a fair fighting chance on a level playing field as much as we can get it, so that hopefully innocent people will be able to properly go free. So that's my rant. Maybe not as angry a rant, but this one bothers me. I've heard it in court from judges, and I'm not going to name any of the judges, but I will name the defense lawyer on that case, and that was Stacey Purser. Great job. Fantastic work. But yeah, let me know in the comments section below what you think. I mean, you might think I'm out to lunch here, but I can guarantee you that if you were accused of a crime, and if you were sitting there and they're, and you're pleading with the court, you're pleading to be heard and to be given fair consideration, you would probably be very upset if at the end of the day the judge said, well, I don't like your evidence because of course you don't want to go to jail. Yeah. Anyway, thank you for watching. Please hit all of the buttons below, like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: CCFR, David Michaud, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.